Good afternoon. My name is Debbie Casey, and I'm a principal with the law firm of Woods Rogers, Vandeventer Black, and I have the privilege of talking to you today about community association law. Just a little bit about myself to begin with. I started my career with Vandeventer Black. The firm merged with Woods Rogers in 2022 to form Woods Rogers Vandeventer Black. And I've actually been with this law firm for my entire 40 years, which next summer will be 40 years. Hard to believe. And I worked for the firm all except for one summer, my second year of law school. So you could say I haven't gone anywhere my entire career. But I think that's a tribute to the firm and allowing me to find and develop this area of law. And so a lot of what I want to talk to you about today is what it involves and how I got into it and how diverse it is, and maybe hopefully entice some other lawyers to come join this practice, which is really a very small bar. It's a highly nuanced field in real estate, and to provide a resource for other general real estate practitioners who don't come across these kinds of issues every day and are looking for some resources for that. As I said, I've practiced in this area for 35 years at this point. I started my career doing other things, a variety of everything. At this firm, we sort of went through a rotation and tried everything. And then I landed in this area through the back door and quite by accident. It really was an accident. At the time, one of our partners, who I credit for giving me this opportunity, owned a condominium and was on the board of directors, and it was not a firm client. This was just an investment that he had, and he asked me to take a look at an issue, and I did. I ended up writing an amendment to the bylaws and met a property manager for that association, and then one thing led to another. So again, it started quite by accident through the back door. But soon after that time, I learned of the Community Associations Institute, which is the trade organization that is dedicated to promoting the community association industry, and it actually is an industry. CAI is the organization to become involved in, and it has a constituent membership of the various professionals, like the lawyers and the architects and accountants and engineers and other service providers who service community associations, partner with community associations, the volunteer leaders who are the members of the board and committees who help run the associations. They're responsible for governing associations. And then the managers and management companies that manage the associations. And CAI has credentialing for those, for the managers and the management companies. So that the three different parts of the constituency, if you will, all converge, and those are the people that we work with on a daily basis. At the time I started, I had to, I was the only one in my firm, as I mentioned, that was doing that, and I had to turn to my colleagues in the industry to ask questions and to discuss cases and issues. What a community association is and what the practice involves were really unknown to anybody else in my law firm. And I'll give you one example of how that is highlighted, which is one of my partners said, well, we have a client who owns a townhouse. And my response was to ask, well, oh, that's great, and you've told me what it looks like. I can picture a townhouse. It's in a row, but I really don't know whether that's a condominium or whether that's a property owners association. And he looked at me and he's like, So I knew what it looked like architecturally. I didn't know what kind of creature, real estate creature, I was dealing with. And so the conversation went from there. And that's probably a good place to start to talk about what the differences are, what a community association is, and some of the differences and maybe some of the statutory framework for that. There are 4 types of community associations in Virginia: condominiums, property owners association, cooperatives, and timeshares. And for the most part, I'm really only going to be talking about condos and property owners associations. Generically speaking, they're all homeowner associations, and you'll hear the word homeowner association or HOA frequently. And what that really means from a generic standpoint is it's some sort of ownership or membership association with it grounded in real estate ownership. Condos are completely creatures of statute, where the individual ownership interest is in a unit that is defined by horizontal and vertical boundaries, with an appurtenant, undivided percentage interest in the common elements, which are owned by all of the owners jointly. The association does not own the common elements, so there's not going to be a deed into the association for the common elements, with a few anomalies as far as whether condominium association will own real estate. But the association is generally responsible for governing and taking care of and controlling the common elements, even though it does not own them. The Condominium Act is found in Title 55.1 of the Code of Virginia in Chapter 1900. And condominiums, as I mentioned, are solely a creature of statute. They've only been around for a little bit longer than I've been alive, actually, starting with the horizontal property regime in 1962, which was ultimately superseded by the Condominium Act in 1974. So without the statutes, there would be no condominiums. Condominiums can be residential or commercial or mixed. Property owners associations, on the other hand, are not purely creatures of statute. Land's been developed with recorded covenants and restrictions, recorded declarations since, land has been developed in Virginia. But the Property Owners Association Act, and there is an act, was only dates back to 1989. So that was after the time that I started practicing in this area. And many developments, even those that were created beforehand, are subject to the act. There's basically 2 things that make a development subject to that there is an obligation to maintain some common areas, and there is also the ability to assess for that. POAs need to have a residential or recreational component to be subject to the Act. And the Property Owners Association Act is found, it's at Chapter 18, so 1800, of Title 55.1. The Condominium Act is more extensive and has more provisions than the Property Owners Association Act. Condominiums must be registered with the Common Interest Community Board, which is in the Department of Professional and Occupational Regulations. Registration is required in order to sell units. In condominiums, you'll frequently probably see a public offering statement that is not part of the documents underlying, but it is required for registration of condominiums. Timeshares also have to be registered. Property Owners Association lots do not need to be registered. So Condominiums and property owners association are forms of home ownership with different characteristics. They're grounded in real estate concepts. Your home is your castle, but so there are a bunch of shared rights and responsibilities, and as practitioners, I spend a lot of my time interpreting those documents, maybe amending them to try to determine who is responsible for what, and what those relative rights and responsibilities are, sliced and diced between the association and any individual owner. We usually represent the associations. We're not generally representing individual owners, and those are kind of two different parts of the practice that may come into play. And even though these involve recorded restrictions and covenants, declaration, they are not contracts, but a lot of contract concepts really come into play. In fact, a lot of judges use contract rules of interpretation when interpreting provisions, but they are not contracts. The practice deals with a lot of contracts between the association and various vendors, and things like management agreements, pool agreements, landscape agreements, construction contracts. So there's a lot of contract concepts that are involved in the practice. One of the appeals of this area of practice is, even though it's grounded in real estate, it really is strongly real estate heavy. The issues that we face on a daily basis really run the gambit. They're everything from constitutional law and construction and employment issues. Insurance is a big part. There's litigation. We're collecting assessments, creditors' rights, bankruptcy, foreclosure, environmental issues, land use issues, discrimination, fair housing claims. So we really cover the gambit. The relevant laws are not just the acts that create or that these clients are subject to. There's a host of federal, state, and local laws that come into play, and issues that are involved, for everything from the Fair Debt Collection Practices Act to the bankruptcy laws and antenna rules, over-the-air reception devices, corporate law. There are regulations at all levels. There's a regulatory framework within DPOR that was largely expanded in 2008 when community management companies and managers, the management companies needed to be licensed and managers need to be certified. So there's a whole regulatory framework to be familiar with as well. Practitioners in the area generally focus in two different parts of the life of an association. Developer attorneys who create the associations when they're put to record in the underlying documents. And then association attorneys who largely focus on, say, the ongoing life after creation of helping to counsel and assist in the work of the association, the business of the association. Community associations are governed by board of directors. It's representative democracy. Those are volunteer leaders, as indicated by the constituent members in CAI. So there's corporate and governance issues that we deal with on a daily basis, election issues, voting issues, how you go about that, what the procedural requirements are, meeting requirements, etc. And as I indicated, they're largely managed by professional managers and management companies. And it's important to, in that management role, to have specific knowledge of common interest communities because, again, they are their own special animal, if you will. The document structure for community associations is key. Communities are created by putting to record a declaration that is found in the land records. Generally speaking, boards have authority to act and make decisions for the association. Boards have most of the power and authority in associations. Homeowners have very little say, but there are some special issues that owners have a right to approve. Some amendments to the governing documents, sometimes budgets, changing assessment responsibility, and the like. So in the practice, we spend a whole lot of time figuring out who has those relative rights and responsibilities, what that authority is, what the restrictions are, how far you can go, can you be amended, can you add to that or subtract from that. There is no typical day in the life of a community association lawyer. Just thinking about yesterday, for instance, because it's top of mind, I usually get up thinking I've got a couple of things I know I need to get through. There's either a deadline or an election coming up, or the board is meeting, so I need to have something to the board or to discuss with them. But yesterday, and I did plan on that because actually I know of a board that's meeting tomorrow and they are revising their rules and regulations, and I thought I was going to spend the day doing that. But I got a call about an architectural submission to know what would be the ramifications of that. There was a situation in a community, different community, in which there was a concern with one owner being intimidated and harassed by her neighbor, and the question was, and she claimed it was based on her gender and ethnicity, was that going to be a fair housing concern that immediate action needed to be taken on to help prevent, or was that going to be more of an owner-to-owner dispute? There was going to be a closing on a unit this week, and they needed a payoff for what their assessment was, and another association had a list of concerns that the board was meeting this week, and those ranged anything from, can we impose a cap on the number of units that can be leased, and what are the issues involved with that, to we want to add some rules to the documents, and we don't know if we have authority to do this by way of rule. Is that something that the board can do, or is that something that's going to require an amendment to the governing documents that the owners would have to approve? And that is just the tip of the iceberg of what yesterday was, but it gives you maybe an idea of how broad this area is and the kind of issues that we address on a daily basis. So I think I'll leave you with that. At this point, feel free to reach out. This is a highly nuanced area that very few of us seem to practice in. Happy to answer questions and maybe direct you put you in the right direction if you have a question that arises. Thank you.